It's wealth and wisdom, time will rise. Educated to sharing the wealth, building things you should do. From trust to breaking, it's all a must. Your guide to work is learning to trust. Let's unite us to feel it right. Dreams to shape with every insight. Wills and assets, life insurance plans, building for your future with expert hands. School talks, money and more. Building wealth with knowledge galore. Asset protection, plans to grow. To read and watch your dreams overflow. From saving today to trust for life. Breaking generational wealth divides. Healthcare directives, taking tips. We're here to help your fortune eclipse. From saving today to trust for life. Breaking generational wealth divides. Healthcare directives, taking tips. We're here to help your fortune eclipse. And now it's time to learn. So wisdom's your return. Invest, protect, and thrive for sure. Signing off is Soul Talks, money and more.
Good morning, good morning, good morning. It is time to rise and shine for another edition of Soul Talks, Money and More, where we believe that money flows, where trust goes, ownership changes your family tree, and when trust matters, learn to trust. I am your host, Dr. Sabrina Edmon Williams, educator, author, and investor, and your life and legacy planning strategist, opening minds and closing contracts. I am so noted. This morning, we are talking about something that many people don't discuss until it's too late. Love, marriage, money, property, children, and legacy. Have you ever noticed how couples spend months, sometimes even years, planning the perfect wedding? Thousands of dollars picking flowers, finding the perfect dress, choosing a photographer, sampling cake, booking a honeymoon. Yet they spend almost no time talking about what happens if one of them dies. If one of them dies. Because the reality is nobody wants to think about death while planning a wedding. But that's exactly why so many families find themselves fighting in probate court instead of celebrating a life well lived. Now, here's something I want everyone listening to think about this morning. And I need you to go on and get up, call a friend, text a friend. This is a serious conversation because many of us are late bloomers. Sometimes we don't get married, maybe until we're into our mid 30s or 40s after we've already become established. Some of us are even on our second, maybe even our third marriages. No judgment on my part. I'm just saying there are some things that you need to know. So go ahead. If not you, maybe someone that you know needs to hear this conversation this morning. Marriage is not just emotional, you guys. It's not. I've been at it 30 years, and Lord knows we've been through some emotions and some commotions in that 30-year period. I'm just saying it's real. It is what it is. Marriage is also one of the biggest financial decisions you'll ever make. When you say I do, you're not just joining hearts. You're joining assets, debts, families, future inheritance, retirement accounts, life insurance, business interests, and sometimes even children from previous marriages or previous relationships. And if you don't have those conversations before you walk down the aisle, somebody you love may pay the price later. Now, just this past week, I don't know if you guys have been following the news. I know a lot of us get our news through social media, so I'm sure you may have seen it on social media. You guys remember Theo from The Cosby Show, Malcolm Jamal Warner? He was Theo Huxtable. Theo actually, Lord, I'm referring to him as Theo. He will always be Theo. His name is Malcolm. But Malcolm met an untimely, very tragic death last year. And even though people have celebrity status, even though they have financial resources many times to be able to afford people like my in-studio guest this morning, we don't always get it right. And in fact, Malcolm's widow has recently filed a lawsuit seeking more than $1.2 million, alleging that obligations contained in their premarital agreement, including a promised life insurance policy and planned estate updates, were never completed before his death. So unfortunate, so unfortunate. Actually, according to court filings, his estate plan had not yet been updated to reflect his current family. Now, let me be clear. We're not here this morning to judge anybody. That is not what we do. This is an educational platform. Only the courts can determine what the legal outcomes will be in that case, and in most cases. But this can be a teachable moment for us if we allow it to be. Good intentions are not estate plans. Saying, I've been meaning to update my will, I've been meaning to update my beneficiary information, does not protect your family. Saying I'll get around to it, I'll do it next week, doesn't get it, you guys. Planning to buy that life insurance policy is not the same thing as actually doing it, actually buying it. Trust me, I can tell you from personal experience. Now, today we're going to answer some questions for you, like, for example, should every couple have a prenuptial agreement? What if this is your second marriage? How do you protect your children from your previous relationship without hurting your current spouse? Should someone who signs a $50 million sports contract get married without legal planning? That's something you got to think about. What if one spouse owns a business? What happens to grandma's house? What happens to that house where we used to spend our summers? What happens if you never change your beneficiary on your retirement account after getting remarried? These aren't just celebrity problems, you guys. These are everyday problems, because estate planning isn't about preparing to die. It's about protecting the people we love while we are living. So today, for this conversation, Dr. Williams has been talking about preparation now for about 3 or 4 years, but I'm not talking about it by myself anymore. And I couldn't think of anyone better to help us navigate these very important conversations than one of Mississippi's finest, most respected, no pressure. Estate planning attorneys. We want to welcome to So Talks Money and More this morning. Attorney Rhonda Cooper is in the house. Attorney Cooper, thank you. We've been talking about this for a while, and we are finally here. How are you this morning?
I am very well, Dr. Williams, and thank you so much for having me. As you said, we started talking about this in November
of last year.
And
it's almost November of this year.
Again, but in this instance, timing is everything. And so I just want to thank Dr. Williams for this opportunity to speak to our listening audience this morning. So happy Monday, everyone.
Well, we don't only have a listening audience here. We also have a viewing audience, because we do stream our show live both on Facebook as well as YouTube. So you have people around the country, actually, because a lot of our YouTube viewers are actually in other states. Right. So Attorney Cooper, let's just jump into this. I know people, when they hear the words estate planning, they immediately think, well, I'm not rich, I'm too young, I don't own anything, or I don't have enough assets. Why do you think so many people wait until after they're married, or sometimes never, to have these conversations?
Well, unfortunately, we think time is on our side,
Mm-hmm.
and time is not. And to think about estate planning, of course, is to think about the inevitable, and that is passing. But because it is inevitable, that means that we have to give a lot of thought to it. And the planning is just simply planning for the future. We are not always going to be here. We have loved ones for whom we need to make provisions, whether it's a spouse or children or even friends or charities. But we have to give thought to it. And that's just something many of our community members are not wanting to take the time to do.
We, I always say, especially when you grew up in the Baptist church like I did, everybody want to get to heaven, but nobody wants to die. We want to go, just get caught up.
Just get caught up. And even in our counseling with our clients, we even have to ask as we're preparing the wills, what are your provisions? What have you done in terms of your funeral and burial? And then that brings about another side,
Mm-hmm.
because that's another thought to which we don't always want to give time. But I mean, the death brings about grieving. And what I have found in my 10 years of service next door to Jack's Memorial Funeral Home, I share with my clients the grieving, of course, starts at passing. You go spend time with Mr. Muriel and his staff to make the plans and arrangements. And then if I'm fortunate enough to serve the families, now you're coming to my office and the grieving continues. And it's been my experience that if the families have made substantial provisions, putting in the time to make the plans, it doesn't lessen the loss or the grieving for the loved ones, but it does take the sting out and the angst and sometimes the anger that goes along with the planning for the administration of the estate. And that's all business. And of course, it involves the Chancery Court. But where you're simply following what your loved one has directed and intended, that's not as difficult as having to think about, well, what to do now, where there's
what they would have wanted.
What they would have wanted. And then that brings about arguments among siblings and sometimes family members who don't even stand to inherit. But because of the blood relationship, they think, well, I should get something. I'm the sister. Well, this person had a spouse and or children. So now where does the sibling come in to receive something? So it's just a conversation that needs to be had. Even if you decide, well, I don't want to do anything, which I've had some clients to leave my office saying, you will have had some information that you can at least consider and maybe share with your family members. So then if you pass without having done anything, they will at least know, well, this is what I need to do. And more than not, you need to consult with an attorney. I just did an estate planning workshop just last Tuesday evening, and everybody was talking about, oh, well, I pay the taxes. But
Sounds
that
familiar.
does not give you an ownership interest in the property. And paying the taxes is not going to automatically divest the deceased person's interest and have it transferred to those who are living. And of course, the person who's paying the taxes, it's still going to require intervention by the Chancery Court.
Well, Attorney Cooper, just for the people in the back that may not have caught this, because I heard you say something. Now, her office is located right next to the funeral home, you guys. So you can either come see her first and then go to the funeral home, or you can go over to the funeral home and then come see her. That is well positioned. You playing that. I see what you're doing. One way or the other, you're going to have to see her. I like that. So let's jump into this. Let's start here. Let's suppose two people fall in love. One owns a home, the other doesn't. One has children, the other doesn't. One owns a successful business. The other is just getting started. Should these conversations happen before the wedding, in your professional opinion?
Most definitely. Because again, we're talking about honesty, integrity, that we don't want to have any surprises. So if you're planning a wedding, then you have to plan the property and other interests that you have as a single person who's now going to be joined in matrimony. For the for the party that has children, do you want to make provisions for your children? Do you want your children to own your home, or do you want your spouse to have an interest in your home? So, for example, if that couple marries and there's been no provision for the children, and the person who, or the now spouse who owns the home, when that person passes, your spouse is automatically going to be one of your heirs.
Mhm.
So the home that you say, well, I want my children to have it, but if you've not made the necessary provisions for the property interest to pass to them and them only, then your new spouse is going to share in that. You die with 2 children and a husband. Well, now your husband is going to have a 1/3 interest in your home to share with your children. If that's not their parent, then oftentimes that's going to create some
That's
issues.
when it gets messy.
It gets messy, and again, there's going to have to be intervention by the Chancery Court as it relates to the business. Well, that's a discussion that you have to have also, because do you want your spouse, who may not have had anything to do with the establishment of the business, paying into it in any way, maybe not even be able to provide any services that the business offers? Do you want that person to share in any of the proceeds? Well, first you have to decide, what do you want done with the business?
With the business,
do you
right.
want the business to be sold at death? Do you want the business to continue? Do you have a partnership in that business? And does that partnership agreement have to be revised now that you're married? So despite the fact that we don't always want to talk about these issues that we think might hurt someone's feelings or leave someone feeling some kind of way, I like and practice by the philosophy, pay me now and pay me later. And I'm not suggesting hire a lawyer and thus pay me, but deal with it on the front end, because once you're gone, then you're leaving those again who are grieving to now have to make and participate in decisions about which they have no knowledge. And that is definitely going to increase the angst, the anxiety, and the anger, and these bad feelings that come about because people are having to make decisions that they're not necessarily equipped to do. That's just going to be long lasting. And it's hard to bridge those relationships once they've been severed, just because someone failed to have the conversations that were so critically necessary.
Okay, ladies and gentlemen, good morning. If you are just tuning into So Talks Money and More, this morning we are having a very frank, very open, very honest discussion. Love is blind, but hey, we may not need to be too blind when it comes to making sure that we are properly preparing our estates, properly handling our business. So this morning we are talking about the things that you should do before you say I do, with our in-studio guest this morning, attorney Rhonda Cooper, who is one of our esteemed estate planning attorneys here in the state of Mississippi. Now, Attorney Cooper, one of the things that a lot of times people don't talk about, or they hesitate to talk about, is their financial status with regards to their debts that they bring into a marriage. Have you ever had a case where, or a client where that became an issue? Because, you know, people come with baggage, actually, especially some of the times when people are maybe on a second or third marriage. There could be a great level of debt that comes with that individual. What are some of the things that you might caution people to consider when they find themselves in that situation?
Well, I have to share this funny, and I can look back on it and say it's funny now, but when it was shared with me a little better than a year ago, I kind of raised my eyebrows. But I was having dinner with a friend, and he shared with me that as he was dating, the very first thing he asked the lady with whom he was dining, "What's your credit score?" And I was like, really? That's the first thing you ask? But to his credit, he's been a very hardworking man, very industrious. You know, that was his background, and that's what he's carried into his now mid-60s. And so that's important to him. And there were marriages that he did not go into or relationships because these people did not have good credit standing. What we do know is, as a married couple, you're taking on whatever that other person's background is, be it social, emotional, and financial. So I think it's a conversation that has to be had. Now, people are not always honest about their credit standing, but I think now in the age of technology, all the social media, all the access that we have, you can find out what someone's credit score is, because that's going to impact your ability to purchase those assets that every couple wants to have.
Build wealth.
Generationally, you're going to have children. Will you be able to invest financially in your children's future? And what I am finding is, particularly with these young couples whose backgrounds are not always the same, and by that I mean, whether you were a work ethic was instilled in you as a child, and that's what you know, and that's the path going forward. Then you have only one person within the marriage who's going to own the home. And so there's arguments about, as a married couple, do you want to be the person who's the only names on the home because you're the person that had the better credit? Then that means that's going forward in terms of automobile purchases, furniture purchases. And so one person might be credit worthy where the other isn't. And how's that going to impact your future together? Because if and when that marriage dissolves, you're going to have one person whose credit is going to be impacted because for the last 10, 12 years, we've acquired everything in my name. Now, the person whose name is not on these tagged items, now they're free with getting the benefit of the other party's credit standing to now make those purchases that they couldn't when they were engaged and now married. So conversation. And don't be afraid. If you're presenting these topics to someone who says they want to marry you and be your life partner, and they feel some kind of way because you're questioning them honestly, then I think maybe that's the red flag that you might need to heed, because that's just the beginning of what might over the years become rather nightmarish. And we do know, or at least I've seen in my practice, that marriages do end oftentimes because one party is bearing the financial load and the other person is, and over time begins to take advantage of that. And that does bring about some discord in the marriage and the relationship.
Now, I want to throw a question out there for our listening audience and our viewing audience. And if you want to drop your response in the chat, if you're on Facebook or on YouTube, please go ahead. You don't have to feel obligated. But I'm just curious, how many of you ever had a conversation with your spouse or your fiance, somebody you may be considering marriage? Have you had that conversation about what would happen if one of you passed away? On the case of Malcolm Jamal Warner, unfortunately, death doesn't always announce itself. It's not always a situation where people, have some type of long-term illness where you have time to prepare. Sometimes it just happened. It can just be, that unexpected car accident, or that unexpected accident when someone's on vacation. We see the person today and they're gone tomorrow. So are we really engaging our spouses, these people that we are thinking about marrying, about what happens if I should pass away unexpectedly? And Attorney Cooper, I'd like to kind of hear from you. Has that been what has your experience been like in your practice? Are you finding that people are having the conversation, or is it being delayed?
The conversation not only is being delayed, Dr. Williams, it's being denied.
Okay.
People are just not talking. They're not talking about the things that they should discuss. Unfortunately, one of my sorority sisters just lost her husband maybe 3 weeks ago now, and they had 2 children. That was unexpected. And I think at a minimum, even if you're a single person, you might just want to consider getting a life insurance policy that you can afford, because if nothing else, it's going to cover your funeral and burial. You have a lot of millennials who say, well, I don't want to be funeralized. I don't want to be buried. I want to be cremated. Well, that costs too.
Yes,
So
it does.
Nothing is free. So, just you have to, it's responsibility.
Mhm.
It's certainly being responsible. So if we can go and buy the car for which the state mandates you have insurance, you purchase your first home, you must have homeowners insurance. You are a walking, living, breathing individual. Why not have insurance on your life? Why pass that cost on to your parents or other loved ones if you're able to afford it? And I know life insurance policies are still very affordable.
Mm-hmm.
So that's just you as a single person. Now, if you've had that stewardship over yourself and now you're partnering with someone, why not ask and say, well, hey, why don't you consider that? That's a nominal monthly expense. You've got your phone bill, you've got your lease or your mortgage. Just add that very nominal expense, because that will then take the financial burden off of the person, the next of kin, as the funeral home industry recognizes, as the person who's responsible for the disposition of your body.
Mm-hmm.
That expense will be taken care of. That alleviates, and of course, as Dr. Williams has said, because it is unexpected, now we're having to borrow from family members or do GoFundMe accounts, and people are willing to help, but they're going to say, why didn't they have insurance, especially if you have children? I mean, it's just good stewardship.
Well, Attorney Cooper, I can tell you from my own personal experience, most of my listening audience and viewing audience know that our family did experience loss earlier this year, the loss of my firstborn granddaughter.
Yes.
And I can remember distinctively going to the funeral home, and the funeral director was very kind, very soft-spoken, much like yourself, very soft-spoken, very compassionate. And, we discussed all of the different options and various plans. And, he just made everything very clear about where we were headed. But at the end of the conversation, I distinctly remember him saying, how will you be paying for this today?
Yes.
Funerals don't come at, they're not free, no matter what the circumstances are, no matter what the age of the person that passes away. So we have to get this right, family. We have got to start taking a different approach in our families, in our community, about how we handle our responsibilities. Now, I'm looking at the time. We're coming up on the half hour. This is generally the time when we go to a short break. But on the other side of the break, come on back, because we have a phenomenal in-studio guest this morning, Attorney Rhonda Cooper, who is a premier estate planning attorney here in the state of Mississippi. And we are talking about some things that many of us probably should have talked about a long time ago. Some things we need to think about before we say I do. So I'm going to throw it to you, Mr. Armstrong, for a quick break, and come on back on the other side.
Hello, this is Dr. Sabrina Edmon Williams, educator,
We are.
and host of So Talks Money and More. You are invited to start your week at 7 a.m. on Mondays, right here at WMPR 90.1 FM or online at WMPR90.1.com as we educate, enlighten, inform, and empower our community about the importance of building, protecting, and transferring wealth. If it's Monday, so is Talking Money and More. So Talking Money and More is a proud underwriter of WMPR 90.1 FM.
It's 7 a.m. Let's rise and shine. Smart talks money, the future's alive. Grab your coffee, let's take a ride. It's wealth and wisdom, time will fly. Sharing the wealth, building
Oh, wow.
Legacy like secure it right. Dreams take shape with every insight. Wills and assets, life insurance plans, building for your future with expert hands. Sometimes money and more, lands in wealth, knowledge galore. Asset protection plans to grow, dream and watch your dreams overflow. From saving today to trust for life, breaking generational wealth divides. Healthcare directives, banking tips, we're here to help you function eclipse. From saving today to trust for life, breaking generational wealth divides. Healthcare directives, banking tips, we're here to help you function eclipse. So tune in now, it's time to learn. So wisdom's your return. Invest, protect, and thrive for sure. Signing off is old talks, money, and more.
Good morning, good morning, good morning, and welcome back to the second half of So Talks Money and More. I am your host, Dr. Sabrina Edmon Williams, educator, author, and investor, opening minds and closing contracts. I am so noted, and I am so excited and so delighted to be here today. We have a phenomenal conversation going this morning. This is one you don't want to miss. Call a friend, text a friend, wake somebody up, because we know people that need this information. Our in-studio guest this morning is attorney Rhonda Cooper, who has graced the studio this morning to share with us her knowledge and her experiences on this thing we call estate planning. Now, attorney Cooper's statistics tell us that many marriages today are second or even third marriages, and that creates an entirely different set of estate planning issues. Now, let's say, for instance, a husband has 2 children from his first marriage, or a wife has 3 children from hers. Together, they buy a home. So now we got 2 on the husband, 3 for the wife. So that's 5 children total. That's a blended family. And they buy a home together. What should they be thinking about in this instance?
Well, the first thing, who's going to get the home when one of us passes? So what I am hopeful in purchasing their home together, of course, that their deed should have the language as joint tenants with the right of survivorship and not as tenants in common. And what that means is the surviving spouse will own the home to the exclusion of the deceased spouse's creditors and all of the children, his children, her children, and any that they may have together. And I think that's perfect, because we want the surviving spouse to have the full ownership and benefit of the home for purposes of exemptions. If going forward they are in need of any finances and needing the house to collateralize it, that takes away any creditors that the deceased spouse may have had, and certainly doing away with the interest of the children who said, well, that was my daddy. I got an interest in the house because he had an interest in the house. No, the language that's stated in the deed specifically gives that surviving spouse the rights to sole ownership. But then the surviving spouse needs to do whatever plans. And what we've had is, in that instance, we've had that each spouse should make his or her will. That way, if you are the surviving spouse, then you can say at your passing to whom you'd like the house to go. And where couples have had the conversation before coming to me, they've talked about what to do, where the children are not theirs. So if there's some funds that the father, in this instance, that has the 2 children, if he's got some funds that he wants to leave solely to benefit his children and the children of his children, the grandchildren, he's well within his rights to do so, as the same with the wife with the 3 children. Now, what happens when the couple comes and they've not had the conversation, and sometimes I think, and more so the husbands, and I'm just going to lay that where that is, they kind of use the conversation with me as the way to share with their spouse what they're thinking. Mm-hmm. And I just sit there and listen, of course, but I've had situations where the husband said, well, I want to leave to my children, the children that are not those born to the marriage, whatever gifts he wants to make. And then this is the first time that the wife is hearing this. Mm-hmm. And so, of course, she's surprised because, of course, she's thinking about her children, either her singularly or those that she has with him. So ideally, the recommendation would be that each spouse make their respective wills. In the event they are that surviving spouse, then they have the sole right to dispose of the property as they so choose. And then that's just the conversation that we have, and we just develop it because I have to encourage my clients to think as far into the future as they can. Making provisions for grandchildren because a lot of people are interested in that. I now have a 14-month-old grandson, and my whole estate planning has changed. I did my first will when my daughter was 5, making provisions for her in terms of a guardianship if I were to pass. I think I looked at it again when she maybe was 16. And then I changed it when she became 21. As an adult, we no longer needed the guardianship provisions. And at that time, my thinking was she'll have everything with the exception of things that I wanted my niece to have. And now that she's 3 years into her marriage and a new mom, I'm making changes now to benefit my grandson and any siblings that he will have, because the need for my daughter to have those funds, of course, has changed. So we have to, circumstances and time dictate what needs to be done. But just as we change cars annually, or however often people change cars, or even upgrading and making changes to the home to increase its value, we have to do those same things with other assets. And that's where either we have a will, or I just counseled a lady who is marrying for the 3rd time. She has adult children and grandchildren. So she wanted to dispose or create interest in her properties to benefit her children. And so now as she prepares to marry, she and her husband, whatever property they acquire together will be theirs, and prayerfully we'll have a conversation at that time. But the property that she has purchased, maintained, and invested in over the years, she has made disposition of those to benefit, others, so that her husband won't receive the benefit of that to the exclusion of her children. So we have to be mindful when we're going into these marriages, in our 50s and 60s. That's different than 30s and 40s, because I have a client now that's very advanced in age, and his marriage has ended. My thinking is, how do I ensure that he has the financial resources that he needs for the next 10 to 15 years? Because he spent so much of his past earnings investing in the home that he and his wife now have. So for the 10, 15 years that he has remaining, I think it's prudent of me to be mindful he's going to need some of the money that he would have had had he not invested so heavily in this marriage that is now ending. So I think you just have to think about those things, because he will not have the opportunity, just based on time, to acquire any more wealth.
Now, Attorney Cooper, this is my attempt to add a little humor in here. In this case, would it be cheaper to keep her? Mr. Armstrong answered that. He said, yeah. Might just be cheaper to keep her.
Okay.
Yes, okay. Well, in all seriousness, what I heard you say, and I don't want us to, in our having fun in here, I don't want us to miss this point. An estate plan is not something that is static. It is dynamic. As your life changes, as your family's dynamics change, so should your estate plan. And I'm the same. I love my children dearly, but I'm in a season of life where I am clearly thinking about Miss Yvette.
Right.
I was focused on the boys before Miss Yvette came on the scene. And so now I am thinking about what I can do, what I need to be doing to ensure that I am thinking about my children's children
Right.
being the recipients of those excuse me, things that I will leave behind. Now let's shift the conversation
Sure.
right here, because many Black families have land
Mm.
that's been in their family for generations. Grandma's house, the old family farm, property that's been paid for.
Mhm.
And sometimes people remarry,
Right.
never update their estate plan, and then years later, the children and the surviving spouse finds themselves in court,
Mhm.
not because, and sometimes it's not even because people are trying to be greedy, it's just because mom and dad, or whoever the initial owners were, never made their wishes legally clear. So let's talk about that. This thing called heirs property. Excuse me, got a little frog in my throat here.
Same here.
Mhm.
Well, let me applaud the families. I'm just always so delighted for the families who have been steadfast and have been good stewards of the properties, particularly the acreage that they have maintained throughout the decades in their families. Because we find so many times that when the properties remain in the grandfather's name who died in the 70s and it's still in his name, and then there's one family member who's been dutiful about paying the taxes, but as I said earlier, that doesn't automatically convey the ownership. And then when that person passes, now there's no one paying the taxes, and the family then loses the property at a tax sale. So for those who have been good vanguards in paying the taxes, I applaud them. But we have had situations where the property, the heirs, maybe there were 10 or 11. And now I did just complete an estate where there were 60 heirs, but they sold the property during the estate. So each of those heirs will get some funds. And no, I think of the 60, we may have had 5 that were Mississippi residents, and they were great grandchildren, so they had no interest in being owners of the property. But if you've got 10 siblings and you know that you have an interest in this property, whether it's been properly divested from the deceased through an estate administration in the chancery courts, you still have to make some provisions, because now when you pass and you're married with children, they are now going to succeed to your interest and share your 1/11th interest. And the only way they can get that or have any opportunity to receive any funds if the property is sold, if there is an estate administration. And that's just, because the person who was on the deed passed and it never was divested. You're not going to just have ownership because that was your granddaddy and you're paying the taxes. But
Wait, hold on, because I get asked that question all the time. So let's put this out here in the atmosphere for all these people that have a misconception. Because I am the one paying the property taxes, then I have, sole ownership rights to the property because I paid the property taxes. Is that accurate?
No, because taxes is just what we're supposed to do. We need to pay the taxes so that we don't lose the property. The property is owned by whoever's name is on that deed. If that's your grandmother and your grandmother's been gone for 25 years, then her estate is still going to have to be opened and administered through the chancery court to divest her interest in it, and it thus be granted to those who are her heirs. If you are the heir that's been paying the taxes, and if the property is sold, then of course you get those funds back. You get that off the top. You will receive those monies that you have paid over the years, and you will receive your proportionate share of those proceeds. But paying the taxes does not equate or bestow upon the taxpayer ownership.
Okay, we got that cleared up because we get asked that question
Yes.
all the time. Well, I think I want to move into probably what will be our final question because I want to leave a little time at the end for you to kind of share some information with our audience. One of the biggest misconceptions people have is talking about estate planning. Attorney Cooper, is especially when we're talking about it before marriage, that somehow means that you don't trust the person you are thinking about marrying. What are your thoughts on that?
Well, it's not an issue of trust on in a negative sense. It really should be I trust you enough
Mm-hmm.
to discuss with you what my assets are or what my philosophies are about finances and how I would like for us to live our life together. Because as I said earlier, a lot of the divorces that I have participated in the past have been over finances.
Mm-hmm.
Just not having the relationship to even discuss it, and one person is now bearing the brunt, and then that wears and tears the marriage. It's not a matter of trust from a negative sense. And so if I'm suggesting to you that this is what I'm bringing to the table, and we have to understand that not all marriages last, so in the event
Mm-hmm.
our marriage does not last, then this is what I would like to leave with.
Mm-hmm.
I mean, that's just being honest. Now, we want to have God very much a part of that. And if this has been a praying couple, then I think that conversation should go very well. But if that's not the case, and I think we have to heed the red flags. If you're telling someone this is what I would like over the course of our marriage, because this is what I'm bringing to the marriage, and they give you some pushback,
Mm-hmm.
that's a red flag.
Mm-hmm.
Because now we're knowing going forward, we're not going to be able to share in the information that should be shared between a married couple. And I have counseled couples with regard to prenups,
Mm-hmm.
with prenuptial agreements. It was an older gentleman who had been in a very, very long first marriage and came out of it, as he said, unscathed. So I guess because his wife had worked right alongside with him, they were able to divide up the property pretty equally. But he came to me saying, I'm marrying someone much younger than me. I think she only wants me for my money. So
Gold digger.
Yeah, he saw that. And,
He's a gold digger.
as we talked about it, I'm like, is this something you want to do? And the more we talked about it and we started laying out the agreement, he, kept saying, well, let me get back with you. Let me get back with you. And finally he said, you know what? I'm just not going to marry her.
Mm-hmm.
Because he just, I think everything was there for him to make that decision, but because he had been so accustomed to being married,
Mm-hmm.
but he was marrying someone that was younger than him, who did not share the work ethic, who did not value all that he had acquired. So he just came to a really good decision that, I think he realized if I marry this woman, I'm not going to be as successful in resolving it as I was in my long marriage.
Mm-hmm. So sometimes that's something we have to consider. Just
Did I
because,
answer that
yes,
okay?
you did. Just because it worked out for you the first time, the first go around, and you were able to divorce and walk away with the shirt on your back, you may not be able to do that the second or the third
Right,
time. I'm
that's
just
right.
saying,
That is so
sometimes
true.
it don't work out like that. Now let's shift the conversation just a bit, Attorney Cooper. Could you please, I know you said your office is located next to the funeral home. So again, you can either see her before you go to the funeral home or after you leave the funeral home, but one way or the other, she is strategically positioned so that you will see her. So could you please tell our audience where you're located?
My office is 922 West Woodrow Wilson Avenue. And for the Jacksonians and those who have done business with Jack's Memorial, you all know that my office was formerly the funeral home. So it is situated between the funeral home and now the event center on Woodrow Wilson. And I've been in that location now for 10 years. And it's really been a blessing to continue to serve the community from that location. That's the Georgetown community. We have served in the Midtown community. We have served from Fair Street proper. So we have been invested in Jackson over these last 38 years.
Okay, Attorney Cooper, are you still accepting clients now? I know you have some things, you're kind of getting ready to make a shift here, but are you still accepting clients?
Still accepting clients because, and even if I'm not able to serve, I'd like to have the conversation. I do have some wonderful young lawyers in place standing ready to assist me, but I decided at the new year, after consulting with my family over the holidays, that I would seek a chancery court judge position. So I am seeking to serve the citizens of Madison and Lee County, District 11, Subdistrict 2. That district is a 4-county district. Yazoo, Holmes, Leake, and Madison. There are 3 seats. I'm seeking the 2nd seat, which serves, as I just stated, the citizens of Madison and Lee County. The election is November 3rd. So that's just not very long, not far away at all. The time this year has just gone by so very quickly as we've been meeting and greeting the citizens and just being a part of the communities that I have served over the years. I've been blessed to serve clients all over the state of Mississippi in the Chancery courts as an advocate. And I think at this season, we'd like to shift it to serving as a activist, if you will, in the resolution of cases. As we started this conversation with Dr. Williams, time is not on our side. And in the people that seek the services of attorneys where their matter is pending in Chancery Court, they too don't have a lot of time and the resources to continue going back and forth to court, fighting for the relief that the statute says they're entitled to. So we're just hopeful that we can make a difference in serving from a different lens, from the bench, as opposed to from the bar. So thank you, Dr. Williams.
Okay, now, again, this is an educational platform, Attorney Cooper. So for those that may be listening, there are no dumb questions when you come to Dr. Williams' class. Please explain to our listening audience what the Chancery Court handles, and so that we do understand what type of cases would be seen in Chancery Court.
Chancery Court is considered a court of equity. So everything that Dr. Williams and I have discussed this morning comes under the jurisdiction of the Chancery Court. The divorces that don't continue and have to be dissolved, the children of those marriages, who's going to care for them, who's going to have custody, who's going to provide for their support, and the other benefits to which they're entitled. That comes under the Chancery Court. The land matters that we've discussed, whether it's property that you own, property that you inherit or get to own based on your being a beneficiary under a last will and testament, or you get the benefit of ownership as an heir. Those estate proceedings are under the Chancery Court. Those who die with a will, those who die without a will. All the matters involving the minors and the seniors, conservatorships, guardianships. If you want to make amendments to your birth certificate, you have to petition the Chancery Court. If there are commitment proceedings, all things again regarding the property, if there's a dispute with your neighbor. I was looking at my lawn this morning. I'm like, I might need to get somebody to come and tell me where my property line is, because my neighbor and I were cutting the same little swatch of grass, but when they cut it, the grass is always on my in my driveway. But that's a small matter, guys. But injunctions, easements, even challenges to the state constitution, if there are appeals with your taxes. And of course, as we're, these areas around here are growing, Glusat, that was an annexation matter, Byram, annexation, those matters come before the Chancery Court. They used to say that the Chancery Court was the most powerful court, and I think that was only in terms of the matters over which it has jurisdiction, because it's everything involving the family, your children, your property, when you pass, And then, as I said, those issues as to how do we make the best use of public lands, annexations. Now, eminent domain does not come under the Chancery Court. There's a special court created for that. And for those counties that have a county court, then the eminent domain proceedings are had in those courts. But again, it's a court of equity. So when the matters are resolved, the standard is that it is done justly and fairly. And that is the Chancery Court. And that is the seat that I'm seeking to continue my service to the citizens of Madison and Lee counties.
Okay, well, thank you so much, Attorney Cooper, for joining
You're
us for
welcome.
this important conversation.
It's been my pleasure.
Unfortunately, time does not wait.
It does not.
We sit in this seat, get behind the mic, and time just passes very quickly. So we have to have you back because we only got about halfway through our conversation. But to everyone listening this morning, I have some homework for you. Before this week is over, have one conversation. Sit down with your spouse, your fiance, your parents,
Yes.
your adult children, or someone you love, and ask one simple question. If something happened to me tomorrow, would my family know exactly what to do? And if the answer is no, that's okay. We got to start somewhere.
Exactly.
We have to start the conversation. If you find that the answer is no, don't delay. Start changing that because we have got to do better. We cannot continue doing the same things. And although we wish Attorney Cooper the best in her bid for Chancery Court judge, we don't want you to have to see her if you don't have to. Get your business in order. Fix that. Fix it. So again, thank you so much, Attorney Cooper,
thank you,
for
Dr.
being in the
Williams.
studio this
The
morning.
pleasure is all mine.
It-
And I'm glad that we were able to finally connect.
Finally connect. I know. So until next time, you guys, may God bless you, may God keep you, and may He give you the wisdom to build a legacy that lasts for generations. Have a
Amen.
wonderful week, everyone. Peace.
Take care.
Wow.